Hello and welcome everyone for the lecture series for the preparation of CLAT examination. In this particular lecture series, we were talking about the legal reasoning portion for the CLAT competitive examination. We have till now completed Constitution of India, the law of contracts and the criminal law, and we were discussing about the law of torts. In law of torts, we have discussed about various phenomena that are going to be helpful for you for your preparation for CLAT examination. We have covered what exactly the tort is, what are the different constituents of the tort. We have talked about injurious in damnum, we have talked about damnum sine injuria, and what is a wrongful act, and what are the basic elements of tort, and when a person can go to the court and resort to the different courts that are present to get their rights restored if any tort or any wrong has been done to them. We have discussed about how law of tort is related to the criminal law, it is related to the civil law, and what exactly is the difference between the criminal law, civil law, and a tort law. In our previous video, we have talked about the different constituents of torts, and in this particular video, we will be discussing about the types of torts. Apart from that, we have discussed about the general defenses that are used by the tortfeasor, or if I'll say the wrongdoer, if at all he falls within the categories of the general defenses that is present against the wrongdoer. If he can avail those defenses, he can use that as a safeguard, and he will not be held liable. The general defenses are act of God. If you remember, we have discussed the 6 defenses. We talked about voluntary non-fit injuria. We talked about the act of God. We talked about private defense and the other general defenses that are present in the law of torts. In this video, we will be talking about a different type of torts that are present, and for that we will be moving forward. I would just like to ask you whether the screen is visible to you guys or not. And if it is visible, let's continue and let's see what exactly law of torts suggests about the different types of torts. So in this particular lecture series, law of torts, we are going to discuss the types of torts, and what are their essentials. Once you are able to understand and you are able to differentiate between the different types of torts, and you know what are their essentials, you will be able to figure out that which tort has happened in the questions that will be available in your CLAT examination. So because the concepts are pretty much overlapping, so it is very much essential to understand what exactly are the different type of torts. And once you have understood it, the essentials, you know that for a particular tort to happen, what are the different essentials, it will be perhaps easier for the CLAT aspirants to solve the questions and attain better marks. So let's move forward and let's see what exactly are the different type of torts. These things we have already discussed. Let's have a quick revision for 5 to 10 minutes so that you can just go through all the things that we have studied. When we talked about the tort, we have talked about the tort is a civil wrong. Tort is based on the breach of the duty. So it is based on the duty imposed by the law, which gives rise to personal rights. Civil rights are there. So for all the civil rights, once a civil rights is it's breached, then it acts as a wrong, and then that wrong is known as tort, and that wrong is also known as a wrongful act. Wrongful act, since it is a breach of a duty, means it will give rise to legal right or remedy because of the damages that has been caused. And for the damages, we knew that we have 2 ways to find out whether the damage is with injury or without injury. If it is without injury, no claim can be given, but if it is with injury, then yes, you can claim damages. So we have discussed about the difference between the tort and contract. We have talked about what exactly is tort, what exactly is contract, how are they different. In a tort case, a court will obviously award damages to compensate the victim for the loss. And the difference between tort, distinction between tort and contract lies in the issue of the consent. The consent, obviously, it is given in contract, but not in tort. So these are the things that you need to remember. In contract law, both parties enters into an agreement knowing and without any coercion. But it is not true in regards to your law of torts. In the same way, each party must consent to the contract and its outcome. Okay, but in tort, it is not so. Not so. You cannot guarantee that what will be the outcome, and if the outcome is causing damage to one of the parties, then the other person will be held responsible. Interaction between the parties is based on consent. It is not based on consent, but in contract, it is based on consent. Okay, then we have talked about the difference between the law of torts and crime. We have talked about that it has been usually designated by a specific code. In India, it is about the Indian Penal Code, but it is a private wrong when we talk about tort. An action in criminal law is usually brought by the state or the crown, but in case of the tort, it is brought by the victim. The victim will brought action against the person who has committed tort. The tort action is usually brought by the victim of the tort. The principal objective is criminal law is punishment, but in tort it is compensation. So it is important difference that you need to remember, that for tort it is always the compensation, but in crime it is punishment. So these are the small differences that you need to remember. Now the question is, sir, how will be the questions put up in front of us in competitive examination in regards to the difference between the crime and the tort? The questions will not be directly asked to you stating that, okay, what is the difference between a tort and a crime? No, the questions will be in factual form, and you need to understand based on the way the question has been put up, whether it gives a rise to a tort or to a crime or to a breach of a contract. Because as I've told you again and again, that the questions will not be segregated or differentiated on the basis of the law of torts, the Indian Penal Code. No, the questions will be amalgamated. They will be a mixture of the law of torts also. All the subjects will be combined together, and then the questions will be put in front of you in the form of paragraphical questions. So it is very essential for the CLAT aspirants to understand the concepts of each and everything that we are studying so far, so that they get a clear idea how they have to prepare. Because the questions will not be in such a manner that they will be asking you what exactly is tort, what exactly is crime. No, the questions will be in paragraphical form. So it is understood, and it is perhaps an important requisite for CLAT aspirants to understand what actually constitute a tort, what exactly constitute a crime, and what exactly constitute a breach of a contract. And what are the essentials of the contract? What are the essentials of the crime? What are the essentials of the tort? And in the same manner, you will also be studying about what exactly is intellectual property rights. And if there is an infringement of intellectual property rights, where do we have to resort? If there is a difference, if there is a conflict between international law between two nations, then which organization is capable enough of resolving the dispute? Whether it is the United Nations organization, whether it is the United Nations General Assembly, the Security Council, or the International Court of Justice, or we are talking about the International Criminal Court, ICC and ICJ. So that is why we need to understand the concepts. So it is better that instead of dividing the whole scenarios in on the basis of torts, on the basis of crime, we understand them with a mixture. And that is why it is important to discuss, to understand what is exactly the difference between a crime and a tort, a crime and a civil wrong, a tort and a civil wrong. Because once the candidate is able to understand, okay, this is the difference. In tort, we are being provided compensation. In criminal law, it is the punishment. So you will easily be able to figure out, okay, if it is talking about that it was given a punishment of 6 months, it cannot be a tort. It will obviously be considered as crime. So that is why it becomes very essential to understand the different types of the differences and the similarities between the different legislations that are there. So tort and crime we were talking. And then after that, we discussed about the constituents of torts. Constituents will comprise of three things. First is the wrongful act. We told that if it is the breach of a duty, or to take care, if it has been exploited, if it has not been taken care duly, then obviously there is a damage, and because of the damage, there rises the remedy. The damages again has been classified into two parts. One is injurious in damnum, damnum sine injuria. Damnum sine injuria, we don't get the remedy, but because injurious in damnum, it is injury. And when you talk about injury, it is the violation. It is the violation of civil rights. So what we get? We get compensation. Yes. Then we know why we get compensation, because we have a latent term, latent maxim ubi just ibi remedium, which means that whenever there is a wrong, there is always a remedy. This we have studied? Yes. So in this way, we have understood that what exactly will constitute the tort and what are the essentials. That first, it needs to be a wrongful act. Then there should be available legal damage. That there should be a legal damage. It should be injurious in damnum if we need to get the remedy out of it. And damnum sine injuria is another form where which there might be a damage, but there is no damage or there is no injury. So if there is no injury, means there is no violation of any right, then obviously we cannot claim compensation. But if it is injurious in damnum, yes, we have the remedy, that is through the latent maxim of ubi just ibi remedium, which provides us that whenever there is a wrong, there is always a remedy, and remedy is in the form of compensation. Then we have studied injurious in damnum, where we know what exactly is injurious in damnum. We have studied about damnum sine injuria, that is damage without injury, in which we have understood the case of Gloucester Grammar School master's case, and in injurious in damnum, it was Ashby versus White is the leading case of injurious in damnum. Okay. Then we have studied about the general defenses in torts. General defenses in torts are perhaps very important, because if any of the act of the wrongdoer falls between these defenses, then obviously he will not be held liable, because he has done thing in order to safeguard himself. Let's take the example, voluntarily not finito injuria, which means if we have given a consent, that voluntary consent to suffer injury cannot be used to claim remedy, because you yourself have given consent that yes, I am willing to accept that particular damage. Defenses of the consent in general defense under the law of tort accordingly to the doctrine of voluntary non-fit injuria. If a person voluntarily gives consent to suffer harm from himself, then he is not entitled to remedy under the law of torts. It means that if a person is aware about the risk and voluntarily accepts any task, then he cannot claim remedy. I suppose it is clear to you guys. Then we have discussed the case of Hall versus Brookland in the racing club, where we discuss about a stadium where which we are all the spectators, and if the ball hits any of the spectators, then he cannot claim damages remedy. The reason being, he himself has given consent to watch the match, and once he was giving the consent to watch the match, it was clear that he has if the defendants or the wrongdoer, if I will say, has the defense of voluntarily non-fit injuria, because it was understood, it was clear that once you're going to see a match, there is always a chance of you getting hurt by the ball. So obviously you cannot claim the damages from the from the stadium authorities. In the same way, Hall versus Brooklands Auto Racing Club, plaintiff was a spectator during a car race. There was a collision between two cars. One of the car thrown among the spectators, thereby injuring the plaintiff. It was held that was not liable because the maximum voluntary non-fit injury was applied. Then we discuss about the plaintiff defaults. Plaintiff defaults mean the mere fact the plaintiff was wrongdoer does not entitle him from recovering damage from the defendant. And the latent maxim, very important here. When we talk about any of the torts, it is important to remember and retain the different maxims that are used, because there will be in the principle itself, it will not be asked to whether this particular plaintiff default is considered as a general exception or not, but rather you will be given a maxim like this maxim: ex turpi causa non oritur actio. From an immoral cause, no action arises. So this particular maxim will be given to you in the form of a principle, and then there will be a question that will be put up in front of you. Okay, so I'll just give you an example for your better understanding. The question that will be put in front of you in case of general defenses will be, I'm so sorry. If we talk about general defenses, so first there will be a principle. The principle will be of a maxim. Let's take this maxim only. So you will find mention of maxim of ex turpi causa non oritur actio. And then after mentioning this particular maxim, and then they will say applies as a defense in tort. And then there will be a question or a fact. And they will say that XYZ thing happened between A and B being the persons who have done the act. And now and then there will be questions that will be put in front of you, which you will be asked that, okay, if this particular act has been done, whether the person who has done the act will be considered as a wrongdoer or not. So according to the maxim, what you have studied, you will have to apply your mind and you will have to figure out that whether this particular act can be considered as a tort or it falls within the general defenses. If it falls within the general defenses, obviously you are not supposed to mention that the wrongdoer will be asked to make the compensation, because that is not going to happen. In the same way, we have studied about the case of Bird versus Holbrook. It is a very important case. Why? Because it is not only considered towards the plaintiff's default, but it is also mentioned under the private defense. And the private defense also, this case is important. So you know that there was spring gun trap in this garden to protect his property. Spring injured, innocent trespassed, person sued defendant and claimed for damages. Defendant was held liable. Why? Why was it that Holbrook was held liable? The reason being the spring gun is actually causes a lot of damage. So although plaintiff had done a wrong thing, plaintiff did a wrong thing, so it was a plaintiff default. But the issue was that the setting up of spring guns as a trap in the garden is not considered to be a normal or it is not a natural or moral act, but it is considered as a very severe act, and it can be very harmful. And that is perhaps the reason it was considered to be wrong, and plaintiff and the defendant was still held liable. So this is an important case, you need to remember it. Then you have inevitable accidents. We have discussed under section 81 of IPC also. The same goes here also. The doctrine of inevitable accident is a significant defense in the law of torts, and especially in the area of road accidents. It concerns a situation where a person exercising due to care, diligence and ordinary prudence. So these are the essentials. Okay. So these are the essentials that we need to see when we are talking about inevitable accident, that the person who has been held as a wrongdoer, if he needs to get himself protected under the defense of inevitable accidents, he has to show that he has exercised care, due diligence, and ordinary prudence. It could not have been foreseen or avoided an accident. For example, if we are driving a car on a hill station and we are driving at a speed of 70, 80, 90 kilometers per hour, and then obviously accident takes place because of 2 or 3 people standing on the road capturing the images of the views that are there on the hill station, then it will not be held liable. It cannot be said that the wrongdoer can use the defense of inevitable accident, because obviously he could have not foreseen people standing. The reason is because since he is driving at the speed of 70, 80 kilometers per hour, so there was no diligence, there was no care. So that is perhaps the reason the defense of inevitable accidents cannot be taken by the wrongdoer. So this is how you have to correlate the general defenses with the reality, the practicality, and then only you have to answer in your question papers. Moving forward, then we have studied the case of Stanley versus Powell. Stanley versus Powell, both of them went to the shooting party. There was a branch. The person shot through a gun, and the gun hit the bark of the tree, and it injured the other person who was standing nearby. And it was held whether this person was the person who has shot the fire can be held liable for the act which is done. But it was held that it was clear that defendant on focusing on the peasant. It was held that on this pallet that sheer case of accident and was not foreseeable, defendant was not held liable. So inevitable accidents, the case is Stanley versus Powell. Important case, you need to remember the name of the cases because there are chances that you will be put as a principal. This case will be put in front of you, the facts of the case, and then there will be facts in reality, and then you will be asked that whether this particular the facts that is being mentioned here falls within this particular category of inevitable accident as mentioned in Stanley versus Powell or not. And then accordingly you will have to analyze your mind, you have to apply your mind, analyze the situation, and you'll have to figure out whether this particular fact is within the brackets of inevitable accident or not. Then we studied about the act of God. Act of God, as we have studied, it is an extraordinary occurrence of the circumstances which would have not been foreseen and guarded against, or more accurately, due to the natural cause. So it should not be with human intervention. This is a very important point, and that is what we need to understand, that it should not be with the human intervention. Human intervention shouldn't be there. For example, if there is a construction of a dam and there is a reservoir there, and because of severe rain, okay, so there was a lot of rain that took place in the dam. This reservoir, let's take the example of reservoir, it got filled up totally, and because of which the dam, they opened the floodgates so that the water in the reservoir can move forward, and now because of which there was a lot of floods. So whether it will be considered as a natural cause, the answer is no. It will not be considered because there was a human intervention, and perhaps it will be held it cannot be taken as a general defense that it is an act of God. It will be considered that yes, a tort has happened. So whenever there is any sort of action that takes place because of the human intervention, the defense of act of God cannot take place. It should be naturally occurring. If the flood takes place because of a lot of rains directly, and because of which maybe a cyclone is there, maybe earthquake is there, these type of actions will be considered as an act of God. And another word that has been used for act of God, if you remember, what exactly is that word? Anybody remember that? The name of the word is vis major. Important thing to remember. The another name is vis major, because you might be asked question that there is an act of vis major, whether the defense can be claimed for vis major or not. The answer is yes, because it is nothing but act of God. So first thing, working force should be natural. Occurrence must be extraordinary and not one which could have been guarded against. Okay. Nicholas versus Marshland is a famous case of act of God. Now, Nicholas versus Marshland is a famous case of act of God. Then you have private defense. So you have to remember the cases along with the name of the defense that is there. Nicholas versus Marshland. Then you have when you talk about Stanley versus Powell. What was that? Stanley versus Powell was given in the case of inevitable accidents. Inevitable accidents. And in this in voluntarily non-fit injuria, it was Holbrook's case. Yes. So that is why it is important to remember that what are the different cases and under which case this particular defense has been described, because the chances are that the facts of the case that is there will be put in front of you, and then another statement will be given and you will be asked that whether this particular assumption can be taken that this falls within the general defenses or not. In the same way, we have discussed about the private defense. We have talked about to what exactly the use of force should be there. The force should be justified only for the purpose of defense. And there should be imminent threat. So first is use of force, justified, and third is imminent threat to the person or safety or the property. It can be personal safety or property of the person or relative of the person also. So these are the things that you need to remember when you talk about general defenses. Private defense, again, Bird versus Holbrook case, the force should not be excessive, and because there was spring gun that was installed. So although Holbrook got the defense of voluntary non-fit injuria, but since the act was too excessive, setting up of spring guns. And for a better understanding, spring guns are those guns which eventually, if somebody gets in touch with it and it gets fired, then the person suffers a very, very hefty shock, and it can be life-threatening also. So it was considered that it is excessive force, and perhaps that is the reason the defense of private defense was not entertained by the court, and it was Holbrook who was held responsible for compensating Bird for causing him injury. Then we have talked about necessity. An act, if done under the necessity prevents a CLAT, is not actionable even though was caused intentionally. Okay. Salus populi, that is, the welfare of the people is supreme. This is an important thing. Salus populi. So if there is a necessity and because of which the act has been done, Lake versus Gladstone, very important case. Lake versus Gladstone. It is a very important case which talks about forcible feeding a hungry striking labor to save her life was agreed to be a good defense, and it is considered as a necessity, and the person cannot be held liable for any of the tort that is there. Okay. This was the things that we have studied. We have already studied that mistake cannot be considered as a good defense in tort. And to be frank with you, it is never considered as a good defense, whether it is about the contract, whether it is about the crime, whether it is about the tort, because the court says that ignorance of law and ignorance of law is not an excuse, and ignorance of fact should be avoided. So that is why it is important to remember that mistake neither is considered as a good defense, nor it is helpful in preventing the wrongdoer from making compensation to the victim. When a person carefully interferes with the right of another person, it is no defense to say that he had honestly believed that there was some justification for the same. So even if he justifies it, it cannot be considered as Consolidated Company versus Curtis and Son is an important case, and you should go through it. What are the facts? You can use the internet to get the exact information, but I would recommend that only if you can remember the name of the case along with the general defense which we have been talking about, then it will be more than sufficient for you, at least for the CLAT examination, because you have a clear idea that what exactly are the things that has been covered in that particular case law. Now let's move forward and let's discuss today's discussion about the different type of torts. When we talk about the different type of torts, we need to understand that there are perhaps four major torts which has been mentioned, and we will again be subcategorizing them. If we talk about strict liability tort, they are those torts which are covering the dangerous activities. Then animal attacks, etc. are covered under the strict liability torts. Then when we talk about intentional torts, so intentional torts has been classified into various areas. The first one being assault and battery. Then you have false imprisonment. Then you have conversion. Conversion example could be encroachment. Making some other person's property your property by force or deceitful means is considered as encroachment. Then you have very important tort, that is trespass. Then you have nuisance, and nuisance has been again subcategorized into private nuisance and public nuisance. When we talk about private nuisance, we are claiming that this particular nuisance has been done towards a particular person. Irritating somebody by playing loud music in your house when the person in itself is present in the house is considered as nuisance or private nuisance. But when it is done in a society where which a number of people are living, then it is considered as public nuisance. Both the nuisance are considered to be tort, and if it can be proved that nuisance has happened, then remedy of compensation shall be provided to the victim. Then apart from that, you have these are the intentional torts, and perhaps it is the most important tort that will be asked in your CLAT examination, especially what is the difference between assault and battery, what exactly is false imprisonment. So if somebody has been punished, imprisoned without reasonable grounds, then since his personal liberty, his freedom has been curtailed, that we have studied in our constitution, that his freedom has curtailed, that is perhaps the reason. The main reason behind is that the personal liberty should not be curtailed. And if somebody has been imprisoned without a reasonable ground, then it is considered as a tort, and the person can claim damages by filing a complaint in the court that the compensation of this much of amount should be awarded to me because there is no reasonable ground. Why is it so that I have been imprisoned? So these are the intentional torts. We will be discussing all these torts. Let's move forward and let's try to understand what are the different torts apart from the two torts that we have discussed so far. We have discussed about the strict liability tort. Strict liability tort is those torts which entails dangerous activities which can be life-threatening or which is going to cause severe loss to the victim. Those type of activities, if constituted and which fulfills the essentials of strict liability tort, then it will be held a responsibility of the wrongdoer or the tortfeasor to compensate the victim. Then you have constitutional tort. There is only one thing that we are going to study is by-wins action, and that what exactly is we will be studying in detail in the upcoming video. And apart from that, there is a negligent tort. So negligent tort means tort because of the negligence. Car accidents, etc. Motor vehicle accidents. Due to rash and negligent act or driving constitutes tort. The person should be compensated, because if there is a rash and negligent act, if there is a duty which has been fulfilled, the person who has committed the act, committed the wrongful act, has reasonable ground that he has taken due care, was diligent, and it was not foreseen, then these type of things will be considered as accidents, and there will be no compensation. But let's take the example, if you are driving the motor vehicle at the speed of 100 kilometers per hour and then you meet with an accident, and that was beyond the limits of on that particular route, and that type of things will not be considered as it will not be considered as an accident, but rather a negligent act, and you will be held responsible not only against in regards to the criminal offense, because you are not abiding by the speed that was there mentioned there, but you will also be asked to compensate the victim properly, and that is perhaps the reason it is always recommended not to drive beyond the speed limit whenever you are on the road or the highways. So these are the four major torts, and it covers majority of the areas, majority of the torts that has been there. But apart from that, in India, there are three more torts that is very important. These are very important torts, and they plays a vital role in providing relief to victims. And there is fun thing which is known as vicarious liability. Vicarious liability means liability of the principal for the acts of the agent. So there is a relation between a principal. Principal means a person who has hired somebody, his agent, to do a particular act. Let's take the example of a person who is a driver, and a driver is the agent driver, and he is the owner of the car. Whenever there is an act which has been done by the agent for the principal, and during the course of employment, please remember, during the course of employment, there is any such activity that has happened which constitute a wrongful act, then it is not only the agent, it shall not only be the agent that will be held responsible, but apart from the agent, it shall also be the principal. It shall also be the principal who will be held responsible for that particular wrongful act. Let's take an example for a better understanding. When you talk about vicarious liability, what we are assuming is that there is a relation, a liability of the principal of another person, even for the acts that has not been done by him, but rather by his agent, because of his permission only, the agent actually did the work. So it is the principal, and then it is the agent. So vicarious liability means the liability of the principal for the acts of the agent. Whatever acts has been done by the agent for the principal acts. The agent will only be doing those acts during her course of employment. During the course of employment, the agent will be doing the act for whom? It will be done for the principal? Yes. So the principal for whom the act was done, if the agent does some act which injures, there is a wrongful act which causes damages to a party or to a person, then obviously the agent will be held responsible because he was the one who has committed the act. But it will not only the agent who will be held responsible, but along with the agent, it will also be the principal. That is the person who has hired the agent for the act. Meaning which, let's take an example. There is a commercial vehicle that is being driven by a person with the name of Rahul. So Rahul is driving a commercial vehicle. Let's take the example of an auto rickshaw, whose owner is Mr. Shah. Rahul, while he was driving the auto rickshaw on the road, he hits up a lady who was crossing the path, because of which the lady suffered serious injuries. Now, according to the thought, the agent alone, that the auto rickshaw driver, that is Rahul, shall be held responsible. That is true. But it will not only be Rahul who will be held responsible, but because of the vicarious liability principle under the law of torts, even the principal who happened not to be present at that point of time when the accident took place, he will also be held responsible because of the vicarious liability tort. So in short, vicarious liability tort ensures that it is not only the agent or the person who has been employed by any person or who is considered to be the employer. It should be both the employee and the employer who will be held responsible for the act which has been done by the employee for or on behalf of the employer. And that is nothing but vicarious liability tort. So I suppose that it is quite understandable and it is understood by each and every one of you that what exactly constitute vicarious liability and what exactly has to be done in regards to vicarious liability. So every principal who assigns an agent to do an act for the principal during the course of employment both will be held responsible. Both will be held responsible. So this is what is your vicarious liability. Then we talk about absolute liability. So absolute liability and strict liability are the two things that we will be studying together for a better understanding. That what exactly is the difference between strict liability and what is absolute liability. Because absolute liability and strict liability is perhaps a little bit resonating, because what we see here is that strict liability and absolute liability are perhaps almost a similar terminology, but there is a slight difference behind it. In strict liability, you find mention of some exceptions, but when you talk about absolute liability, you find no mention of such exceptions. And when we talk about defamation is nothing but it is something of defaming the character of a person by statements published which are not true. Yes. So defaming the character of a person by statements which are published which are not true constitutes defamation. So these are the 7 major torts that we are going to study in this lecture, and I suppose the crux, the main principles behind them has already been discussed in this particular segment of the video. Now let's move forward, and let's delve deep in these particular torts so that we can understand what exactly are the essentials to constitute these different torts. So first and foremost, we are talking about negligence. Negligence is considered to be, so we are discussing the 4th tort, that is negligence. Negligence is a tort is a breach of a legal duty to take care which results in damage undesired by the defendant to the plaintiff. Okay, so negligent act is something which is not desired by the plaintiff. So the difference between negligent tort and intentional tort is that when you talk about intentional tort, obviously it is the defendant who had the intention of doing that particular act which would have resulted in a loss or damage to the victim. But when we talk about negligent act, it means that there is a breach of a legal duty, that the person was asked to have a duty to take care, but the defendant did not take that duty, that did not according to the duties that has been mentioned, and because of which there was a damage, which although it was undesired by the defendant, but it actually caused damage to the plaintiff. The essential elements of the negligent torts are that there must be a breach of duty. Until unless there is no breach of duty, then there is no negligent act. To a known standard of care, okay, that the breach of duty was the actual cause and the proximate cause of the harm to the plaintiff, and the plaintiff was harmed to which the law provides a remedy. Okay, take an example. There is a person who has been given a duty that there is a road. On the road there is a manhole. This manhole, it is the duty of this person to assure that nobody goes and falls within this particular manhole, and it is the duty of this person to inform everyone who is passing by that there is a manhole which is open and there is a work going on, there is a work in progress. So you need to be vigilant. But instead of mentioning this point, the person is seen that he is sleeping or is indulged in other activities, which actually, because of that, the person has not been able to fulfill the obligations of the duty. He has breached the duty, and because of which, if somebody falls in this manhole, then it will be considered that because of the negligent act of the guard who was given the duty to inform that there is a work in progress going on, and because of which the person suffered injury, the guard will be held responsible for the negligent act. And I would like to add on here one more thing here, that although the guard will be held responsible, it is so true that the guard will be held responsible because it was his duty to make sure that this particular act has to be done. But it is not only the guard, but the authority also. Why? Why is it so that the authority who has appointed this guard to make sure that nobody falls in this particular manhole, and he should inform every bystander or passers that there is a work in progress going on? Because the authority will be held responsible also because of the principles of vicarious liability. So it means that because of the negligent act of the guard, it shall not only be the guard who will be held responsible, but the authority who has given this duty to the guard to make sure that nobody falls in, they shall also be held responsible. So that is why why have I correlated this particular point of negligence with the vicarious liability, is because it is never a one law that will be applicable in every situation. There is always an overlapping of different laws in different instances. In the same manner, if a person who has been assigned a duty to make sure that nobody falls within this particular manhole and somebody falls, it shall not only be the guard who was not able to abide by the duty, it was also the duty of the authority to make sure that the guard is doing his duty accordingly as has been assigned. So because of the authority not being able to be vigilant over the working and the progress of the guard, it shall also be the duty of the authorities. And because of the principles of vicarious liability, both the guard and the authority can be made liable for the wrongful act, and the person who has fallen into the manhole because of the breach of duty of the guard and the authority shall be compensated. I suppose the thing of negligence is now clear to you, and what exactly constitutes negligence is also clear to you. That there is a breach of duty, no standard of care should have been taken place, because of which there is a proximate cause of harm to the plaintiff. The plaintiff has suffered harm, to which the law provides a remedy. And because of this, there is a case law, very important case law of Donagh versus Stevenson. Important case. We are going to understand what exactly has happened. Establish the tort of negligence. Lord Atkins says that in English law, there must be in some general conception of relations giving rise to the duty of care. So there should be a right of duty of care. Okay, so let's try to understand what exactly happened in the case of Donagh versus Stevenson. So Donagh was the victim here, and Stevenson was the person who was running a hotel. In that particular hotel, the victim, Donagh, went and he ordered a fine bottle of wine. And when he opened it, he found out that there was a dead snail that was present. And obviously, when you have ordered something and instead of that you get a dead snail, obviously it will be a hurtful thing, and immediately Donagh filed a case of negligence against the authorities, that is Stevenson. And it was held that it is the duty not only of the hotel but also of the manufacturer to make sure that Stevenson was the manufacturer, the wine manufacturer, and it was held that it is not only the duty of the hotel but also the duty of the manufacturer to make sure that this type of negligent act should not be done. It is a duty of care that has been given to them because of the nature of transaction that they are doing, and it is perhaps the reason why Stevenson was considered to be the wrongdoer, the tortfeasor, and Donagh was given compensation. So this was the case of negligence. Very important case, Donagh versus Stevenson, and I suppose you will be able to retain it because it is a very important case and you might be asked questions in the same. The House of Lords found that P could not recover damages from the manufacturer, that is, P is the plaintiff here, could not recover damages from the manufacturer even though there was no contract between the parties where negligence allowed the snail to enter the bottle. Enunciated that the neighboring principle, you must take reasonable care to avoid acts or omissions which can reasonably foresee would likely to injure the neighbor. Then who is the neighbor here? Person who are so closely and directly affected by one's act that one ought reasonably to have them in contemplation. So it was understood by this case that the House of the Lords mentioned that there is a neighbor principle. Now, what exactly is the neighbor principle? There is nothing but it is the definition and description of the statement that who actually can be considered that against whom the duty of care should be there. So the duty of care should not only be the person with whom there is a contract, but also with those people with whom there is a reasonable care that needs to be taken, because it can be reasonably foresee that it is them who is going to be injured if at all we are not taking due care in order to save that particular thing from happening. Then who is the neighbor? The person who is so closely and directly affected by one's act that one ought reasonably to have them in contemplation. Here, in the case of Donogh versus Stevenson, since Stevenson know that whomsoever drinks this bottle might suffer harm, and it was the duty of Stevenson, and it was assumed, it is clear by the neighbor principle, that Donogh would have consumed the bottle, and because of which he suffered loss or injury, making it essential for the Stevenson to compensate Donogh. So this is what tort of negligence is. False imprisonment, I've just informed you, false imprisonment will be defined as an act of defendant which causes unlawful confinement of the plaintiff. To constitute false imprisonment, certain factors such as probable cause for imprisonment, knowledge of the plaintiff for imprisonment, intention of the defendant while causing imprisonment, period for confinement matters. So you cannot confine a person beyond the punishable limit. Essentials of false imprisonment: period of confinement, I have just discussed it. Intention factor, that what exactly is the intention, why we are confining it, whether it is for restraining for a certain period of time, for temporary time period, or it is permanent. All these things needs to be discussed when you talk about false imprisonment. Knowledge of the plaintiff, whether the plaintiff knows why he has been fined, why he has been imprisoned, that is also an important portion when it talks about false imprisonment. If all these things are not present, then it will constitute false imprisonment. Place of confinement, obviously the person should know. Now, what are the defenses of false imprisonment? What are the defenses? The first is voluntary non-fit injuria. The person voluntarily has surrendered and he has said that yes, I am the wrongdoer, I have done this particular wrong act. Then yes, he will be imprisoned, and then later on he cannot use the this particular tort as a method of getting compensation, that I was false imprisoned without any probable reasonable clause. But since he has obviously by himself have surrendered, then there is but no other option but for the concerned authority to arrest him, because they have now reasonable grounds to do it. Yes, obviously they should to have a due diligence and cross check, but at a certain point of time they will, if they have valid reasons, they will obviously imprison that person. And then when the consent is there and there is a probable cause, so voluntarily non-fit injuria, if there is a consent by the person who has been imprisoned, and there is a probable cause that yes, he might be involved in this particular act, if that particular action has been done, then it will be considered as false imprisonment. When somebody, what is malicious prosecution? Sue against an innocent man, file a criminal case and is proved that the case is vague. This, it may be called as malicious prosecution. It has been seen in our Indian judicial system that, and maybe in movies and different areas you might have seen that there is a lot of malicious cases that has been filed against the wrongdoers. If we talk about the society in India, lots of criminal cases of domestic violence has been filed against the husband. Maybe because of their small trifles between the husband and the wife prefers to go to the court and file a case of domestic violence, which he claims that the husband has molested her. She has been beaten by the relatives and the husband, which exactly comes out not to be true, but just to take out vengeance against the husband for not abiding by and not adhering to the needs and the requirements and the wishes of the wife. The cases of malicious prosecution takes place against the husband. So it obviously considers as a wrongful tort, and whomsoever has been maliciously prosecuted can resort to the court and demand compensation. International dignitary tort of malicious prosecution may be brought by someone against whom a criminal or civil action be proceeded without probable cause and with malicious intent. So if there is not probable cause and no if it is with malicious intent, then yes, we can proceed with the brought forward in the court of law, and we can take relief as compensation for any act of malicious prosecution against us. Let's take an example for a better understanding. When a defendant admitted that he did not know who actually stole his property, that admission proved that he had the plaintiff arrested from improper motive, leading to a successful malicious prosecution claim. Okay, so I suppose this is very much clear. You can just read things out. I suppose it's more than sufficient for you to understand the institution of continuation of civil or criminal legal proceeding against the plaintiff by or abated by the defendant, the prosecutor or the plaintiff in the malicious action, termination of prior proceedings in favor of the plaintiff. For instance, the case was dismissed. All these elements, absence of probable cause. This is a very important portion when it talks about malicious prosecution. If there is no probable cause for instituting the prior proceeding, malice as a primary purpose of the prior action. Injury or damage to the plaintiff as a result of the prior action will obviously be helpful in deciding what amount of compensation needs to be awarded. So I suppose now the things are pretty much clear to you what exactly is malicious prosecution and what are the elements of malicious prosecution. Obviously, it contains two torts together. Whenever there is a malicious prosecution and if there is a false imprisonment, it is clear that there was a malicious prosecution and compensation should be awarded. You must have seen that there were cases where which a person was wrongfully imprisoned for a crime that he never committed, and when he comes out, he files a case of compensation against the authorities, so that whatsoever loss he has suffered, obviously the time cannot be we cannot take the time back, but for the person who has suffered injuries, who has suffered loss because of actions of some other person, and because of which he was imprisoned, he obviously should be awarded compensation, and that is what exactly is the reason for compensating and understanding malicious prosecution as a tort. Yes, it is not necessary to prove malice because false imprisonment has already been proved. Mistake of fact would not be a good defense. We cannot say that we were not sure that Mr. X was Y and that is why we have arrested him. It cannot be the matter. The person will be given compensation. It is a tort against liberty of movement that I have just told you, and under Article 19. Under 19 Article and Article 21, we get freedom and liberty, which gets curtailed if there is malicious prosecution, and because of which the person can even resort to courts with writs. Writs is something that we're going to study in Constitution, but they can even resort to the court, Supreme Court, and demand compensation, because not only there is a tort, a wrongful act that has been done, but their liberty and their freedom has also been curtailed by such actions. So as we can see, I just informed you that there is always a mixture of different laws combining and providing different rights and obligations over the other parties. It is obviously needed to understand all the different laws by correlating them with each other. So now you can see that it was not only the tort that has happened if there is somebody who has been maliciously prosecuted, their freedom and their liberty will also be curtailed. And that is why it is important to make sure that they are getting compensation and they can file a case of, they can file an application for protection of, for providing compensation, and also again, and they can also file a writ of, there are different writs that we'll be studying in our constitution, and through which their freedom and liberty can be restored. Now, fifth one, actual damage need not be proved. It is actionable per se. Actionable per se means once this particular thing has been proved that there is a malicious prosecution, we need not prove that, okay, damage has been caused. We need not prove damage has been caused. Why? We have studied the case of injurious in damnum. By the use of those principles, we can see that even if there is a malicious prosecution, and although the person might have not suffered severe loss, but still, since his right was curtailed, and what was the right? His freedom of liberty and freedom that was given under Article 19 and 21 of the Constitution of India, they are getting curtailed, they are getting infringed, and that is why the person has injury, that person has suffered injury, and that is the violation of his rights, and that is why he will be given compensation for the same. Moving forward, malicious prosecution, I have just told you and informed you what exactly is malicious prosecution. It is necessary to prove malice, that there should be malice. And by false imprisonment, if we show that there was false imprisonment, then obviously it is clear that malice was there. It must be proved that the criminal proceedings were made without reasonable and probable cause. So if there is no reasonable and probable cause, it clearly shows that there is a malice, and because of which compensation shall be awarded to the victim or person who has been wrongfully imprisoned. I suppose the things are clear to you. Mistake may be a good defense. You can say that there was a mistake or a good defense. In a tort against right not be harassed by the prosecution. Actual damage not should be proved. It is not actionable per se. Actionable per se means, what do you understand by actionable per se? Actionable per se means that it is actionable only when you prove that this particular damage has happened. So it is something where which you need not prove that there is this much of damage has been done. It is only when the person is proved that yes, there was a malicious prosecution that was done, so it can be used as a ground, and obviously the person shall be compensated. This is malicious prosecution. This is pretty much clear to you. And now let's understand what is nuisance. Nuisance is also a different type of tort, and which is considered to be a intentional tort. The word nuisance is derived from the French word nuire and Latin term nocere, which means hurt or to annoy. To hurt or to annoy. Nuisance is an injury to the right of a person in possession of property to undisturbed enjoyment of it, and results from an improper use by another person of his own property. Example of nuisance. I am playing loud music at my house, at my flat, late night at 12 o'clock, because of which the other person who are my neighbors are suffering noise pollution, and they are not able to sleep, they are not able to enjoy their rights, that is to reside peacefully in their own houses. Their right to have that particular peace is being curtailed because of my action of what I am doing in my own house constitutes nuisance. So I suppose it is clear that what exactly can be considered as nuisance. I am playing loud music, I am drilling late night at 12 o'clock at my house, which is causing disturbance, which is disturbing the peace of my neighbors, will constitute nuisance. into two parts. It has been classified. Nuisance has been classified into two parts. I've just explained you in the earlier lecture that there are two types of nuisance: private nuisance, public nuisance. A private nuisance is a continuous, unlawful, and indirect interference with the use of enjoyment of land or of some right over or in connection with it. Okay, so this is against of one person. Private nuisance are three kind. Nuisance by encouragement on neighbor's land. Okay, so what I did, instead of I have a house, I have a property, and I just constructed one more wall, because of which the entrance and exit of my neighbors were curtailed. So this is for example of nuisance. Which nuisance? It is example of private nuisance. Direct physical injury to the neighbor's land. Okay, direct physical injury means that you have built a wall in front of the neighbor, because of which he has not been able to move. He's not able to get the easement rights. Now, what is easement rights? Easement rights are right to have fresh air, right to have sunlight, right to move through that particular area. And those rights, if it has been considered, it will be considered as nuisance. Nuisance by interference with a neighbor's quiet enjoyment of his land. Okay, remedies, abatement, damages, and injunction. So, damages, abatement, and injunction are considered to be the remedies of the private nuisance. Continuous interference. What are the requirements to constitute nuisance? What are the elements? Can we say that if we have played loud music for maybe a fraction of seconds, maybe 30 seconds, 40 seconds, will it constitute nuisance? The answer is no, because it should be continuous. There should be a continuous interfering with the peace over a period of time with the claimant's use of or enjoyment of land. Then it will be constituted as nuisance. Along with this particular requirement, there is one more requirement, that this should be unlawful or unreasonable. If the person is doing something because it is necessary for him to do it, for example, if it is necessary for the tortfeasor to drill a hole in his house because of maybe poisonous gas being filled in his house, because of which he wanted, and there is no door which is being opening. So in order to make sure that there is some way he can make the thing escape out, and there is a reasonable ground because of which he is drilling holes in the doors, that can be considered reasonable ground. Maybe if the person is playing music at around 5:30, where which the sound is not way too much loud, but according to the neighbors, it is causing a lot of difficulty to them, then it cannot be considered as nuisance, because there is no unreasonable action. I am playing music at the permissible decibels, and my neighbors are having problems, and they file a case of nuisance against me, and they call police, and then the police comes up and they ask me to stop the music. My answer to them would be that I won't be stopping the music because I haven't done anything unreasonable. If they would have caused any problem and it would have been unreasonable, please do whatsoever you are within your rights to do it. But since it is not unreasonable, because I am following the policies and the principle that has been given by the law, and there is no unlawful interference. It shall be my right to listen to the music. Even if it might be morally wrong, but it cannot be legally wrong, because morally, if my neighbors are having problem, it is my moral duty to make sure that they are not having any trouble. But if I say that whether it is my legal responsibility, the answer is no. I am not legally responsible to make sure that whether my neighbors are suffering from any sort of interference or not, or whether this completely, because there is no nuisance that has been considered. There is no nuisance that has been done, because had the nuisance been done, it should have been for a continuous period of time, and there should be unlawful interference, and there should be unreasonable interference by me over that particular action. So I suppose the things are clear to you. Now let's move forward, and we try to understand proof that the defendant's conduct was unreasonable, thereby making it unlawful. That the rule is sit utre to ut alienum non laders. So use your own land and not as to injure your neighbors. This is the maxim, very important maxim, and I would ask you to remember this particular maxim, because this maxim has been asked many times in your question paper, that is according to this particular maxim. And then you will be having the fact that, as I just discussed with you in our previous lecture, that according to that maxim, the person will be considered liable or not. Once you have understood it, when you know that what exactly will constitute nuisance or not, you will be able to answer the questions very easily and very firmly. The court will take the following factors into account in assessing the reasonableness or otherwise of the defendant use of land. The locality. If only one neighbor complains, and rest of the neighbors doesn't have any problem, will that constitute nuisance? Answer is no. Sensitivity of the claimant. There are chances that the person who has claimed that nuisance is happening is very sensitive to light music. So the court will take into cognizance to what level of sensitivity, and whether that sensitivity is reasonable or not, and the utility of the defendant's conduct. That why exactly that act, which was considered as a nuisance by the claimant, it's necessary for the defendant or not. So these are the things that one needs to understand, one needs to take care whenever they are talking about nuisance as such, because this is going to help you in understanding that whether this particular act will constitute nuisance or not. I suppose this is very much clear to you, that what exactly are the things, the state of the defendant lands, and then whether there was a malice included or not. Malice is intentional act in order to create irritation. That is malice. You have intentionally done something. The court will take into the following factors into account, assessing the reasonableness of the otherwise. This is that we have already studied. Then interference with the use of enjoyment of land, some right over or in connection, that is public nuisance. Let's discuss public nuisance. Public nuisance is an act affected by the public at large, some considerable portion of it, and must interfere with the rights which members of the community might otherwise enjoy. Does not create a civil cause of action for any person. Does not create a civil cause of action for any person. The reason being, in order that an individual may have a private right of action in respect of public nuisance, the following must be proved. He must show that a particular injury to himself beyond that which is suffered by the rest of the public. That such injury must be direct and not in more consequential of the injury, and that injury must be of substantial character. Because when you talk about public nuisance, whenever you see that there is a construction of road, and everybody is going to suffer from that construction of the road, there will be a lot of noise that will take place. And obviously, if the people will start going and asking to the court that there is a nuisance that has been done by the government authorities, please compensate me, then obviously it will be a very troublesome situation for the courts. So that is why it is an important requisite that whenever there is a public nuisance, the person who makes the claims that he has suffered loss should show that he has suffered loss beyond the rest of the public, and that is why he should be compensated. So what we need to remember when you talk about nuisance, that whenever there is a private nuisance, we are going to get compensation if there are certain requisites which are being followed. And then when you talk about public nuisance, we are not going to cover up those areas which is for the betterment of the public, and majority of the public are getting affected by the same, and it is by the authorities which are doing it for the betterment of the public at large. Example could be construction of dams, construction of roads, constructions of highways. All these will constitute nuisance, but we have to make sure that this is for the benefit of the person. And if at all you have to claim compensation in regards to the public nuisance, you have to show that the particular injury was beyond the rest of the public, and because of which we have suffered the loss. Nervous shock is something that we will not be studying because that is out of the syllabus as of now. But we will obviously be studying about vicarious liability. This is something that we have already gone through when we were studying about the important aspects of the different torts. But now we will be moving forward, and we will obviously be moving forward, and we will be studying about the strict liability and the absolute liability clause. Once we have completed with the strict liability and the absolute liability clause, we will be completing the law of torts. And the law of torts, once over, I will be giving you a certain set of case laws which are perhaps very important for your competitive examination, and that will ensure that your whole law of torts is completed. And not only completed, it is completed in such a manner that whatsoever questions will be put in front of you in your CLAT competitive examination, you will be able to solve it. So I just want to inform you that majority of the portion of your tort syllabus has been completed. The only 2 points that has been left is strict liability and absolute liability. That is what we are going to study in our upcoming lectures. And apart from that, after completing our law of torts, there will be a 5 minutes quick revision of all the case laws that will be that will be coming in your CLAT examination. And I will be making sure that you are reading and reciting each and every case law and how they are related to the law of torts, what will be the benefits of reading that, and how they are going to be in their question paper. And post that, we will be again starting with our Constitution of India. We had left at Article 18. We will start with Article 19, Article 21, and we will complete the fundamental rights. We have completed the fundamental duties, and we have completed the directive principle of state policy. We have completed what exactly constitutes states. And then we will be moving forward towards the executives, what exactly is defined under the executives under the Constitution of India. And then we will be studying about the judiciary. Judiciary is also an important portion that we need to study in the Constitution. And then we will be moving forward with some of the important concepts. We will be studying about the emergency provision. We will be studying about the amendment of the constitutions. And then apart from that, we will be studying about the elections that take place in India. With that, we will be completing our constitution also, and then we will move forward with our intellectual property rights. So this is the timeline that we are going to follow in our upcoming lectures. I would request you to kindly adhere to the practice papers, be consistent for continuously practicing the important previous year question papers, try to solve the mock test, and try to revise whatsoever we have studied so far. Because once you have completed the principles, when we have studied the principles, it is also important to retain them, because you will be having a very limited time period to showcase that you have all the informations and all the things in your mind whenever you are solving the question papers, which will be helpful in getting a good marks in your CLAT examination, and that will ensure that you get a good rank and that you get a good prestigious institution where which you can study the law. With this, I would like to thank you all for being present here, and we will be meeting in our next videos. Till then, goodbye everyone. Take care. Bye-bye.